Thank you, Mr. Chair, members of the committee. I don't think anyone can seriously question the motives and of those who were involved in the drafting and the inspiration for legislation like this, and that's not what I'm here to do. The opioid problem is a serious problem in this state and across the United States, and that's borne out by the statistics, which are really don't do justice to numbers, don't do justice to something like we've heard from Ms. Kutu. On occasion, the criminal justice system is an imperfect instrument, and I would suggest to you that in this context, it is far from ideal. What I would say to you, though, is that we already have laws on the books that do exactly what this legislation would do. So, for example, our murder statute, and you've heard the phrase felony murder bandied about. Felony murder is, simply stated, a death occurring in the course of an enumerated or a non-enumerated felony. In Rhode Island, our murder statute names a number of different predicate felonies, as you heard Mr. Baum describe. And then for those are automatically first-degree murder. And then in second-degree murder can be a death occurring in the course of a non-enumerated felony. And the Rhode Island Supreme Court spoke to that many years ago in a case called In Re Leon. So what exactly does our murder statute say? 1123.1 says in pertinent part, in talking about the predicate felonies for felony murder, specifically says a killing that occurs or is committed during the course of the perpetration or attempted perpetration of felony murder. Excuse me, let me back up. It says a killing that is committed during the course of the perpetration or attempted perpetration of felony manufacture, sale, delivery, or other distribution of a controlled substance otherwise prohibited by the provisions of the Uniform Controlled Substances Act. So that is already on the books and has been for a long time. The penalty provisions for murder, which is the very next statute, 1123.2, specifically says that this type of felony murder can be subject to the provisions of Rhode Island's life without parole statute. So it basically gives the language that I just read to you, and then goes on to say, shall be in prison for life, and if ordered by the court pursuant to 19.2 of Title 12, that's the life without parole statute. That person shall not be eligible for parole from imprisonment. One of the issues that we've heard, or with problems in prosecuting this, are generally what happens in a felony murder case is that the murder is charged and then the predicate felony is also charged. So in this case, it would be delivery of a controlled substance or then the felony murder count. A number of years ago in a decision called Jefferson versus State, what happened in that case was the predicate felony, the defendant was found not guilty by the jury, and the defendant, in appealing that to the Rhode Island Supreme Court, thinking that because there was not a conviction of the predicate felony, that the felony murder count should not be allowed to stand. And what the Rhode Island Supreme Court said in Jefferson versus State was that the conviction need not be a predicate for a murder charge or for a murder conviction. So I think that addresses some of that. Lastly, I would just say that in our drug laws, there is a a defense to some drug offenses when the defendant is a drug-addicted person. However, in our Uniform Controlled Substances Act, it says quite clearly that where the deliverance as prohibited in this subsection shall be the proximate cause of death to the person to whom the controlled substance is delivered, it shall not be a defense that the person delivering the substance was, at the time of the delivery, a drug-addicted person, as that phrase is defined in the law. So, again, there is no question about the inspiration for this legislation. Some of the things, at least one of the things that it does is probably a wise choice to eliminate the language regarding a minor, for example. That statute came about as a result of the Tracy Stewart case many, many years ago. And the legislation also changes to reflect what I just read to you about our felony murder law, that there need not be a conviction for the murder charge to stand. So there are others here far more qualified than I am to address the problem of addiction and relapse and recovery than I am, and I'll leave them to their testimony. So with that, I'll answer any questions you might have.
Representative Corvese.
How are you, Mike?
I'm okay, Rep.
Mike, so if I hear you correctly, you say that there are laws on the books that would do exactly the same thing that this legislation does.
Yes.
Have you had any conversations with the Attorney General's office to determine why, if that is the case, or your perception of that, why they put this particular bill in?
I have not.
Okay.
I'm happy to do that. As you know, I'm happy to sit down and talk to anybody on either side of an issue.
Because
at all times.
I would doubt the Attorney General will put in a law that will be duplicative in purpose. So there may be a dichotomy of thought between you and the AG's office on that.
Well, all I can say to you is that I've known Mr. Baum for a very long time and have the highest respect for him, as I do for Ms. Limbeck, and I think you know that.
I do.
Representative O'Grady.
Thank you, Mike. We heard earlier, I can't remember if it was the Attorney General's, one of the Attorney General's representatives said that this law was intended to apply only in the cases of an overdose, as opposed to, something that might result as, something that might take place as a result of impaired judgment, which is what I was concerned about. Do you view this as being limited in the way it's written to overdoses, strictly defined?
I think so, but the problem as I see it is when we change, we've had felony murder has been part of the common law and then part of statutory law in Rhode Island for a very long time, and there's a body of decisions that explain its application and when it applies and when it doesn't, like the case that I just mentioned to you. So that's why we're leery of enacting a completely different statute that maybe would have unintended consequences. Just what those unintended consequences might be, I think is what you're asking me. All I can tell you is that I'm continuously amazed at the variety of fact patterns that come up in all criminal cases.
Thank you, Mr. Chairman. Mike, for the benefit of the committee, I just want to, maybe you can help us reiterate a fact. I seem to recall from the testimony of the representatives from the Attorney General's office that Kristen's killer was brought to justice and pled to second-degree murder under our existing legal framework.
That was my understanding, too.
Right. And also, I think just for the edification of the committee, in response to Representative O'Grady's question, the word and the concept of overdose is not in the proposed legislation. And given what Assistant Attorney General Baum said, I don't think that's what we're looking at here. I don't think this is an overdose thing. This is about people who make the choice to deliver or sell these substances with with the synthetic substances inside, the lethal synthetic substances inside of them. And so when you just think about the fact patterns, which you just talked about, it seems to me that if you could have somebody who would sell the substance or deliver the substance, not knowing that it was laced with the fentanyl, somebody dies, and they could still be prosecuted under this law. Do you read it that way?
I do, but I also see that they could be prosecuted under the felony murder.
They could be prosecuted under the existing framework that we have now.
Yes.
The prosecutor has a choice of laws.
Yes.
Right. Okay, thank you.